This is William and Lonsdale, and we're thrilled to be back with new episodes and conversations with the fascinating people that make our justice system tick. This week, your host Michael Green speaks with His Honour Iain Ross, Justice of the Federal Court of Australia and President of the Australian Fair Work Commission. It's challenging to keep up with Iain's many career moves, from ACTU Assistant Secretary to Vice President of the Australian Industrial Relations Commission, from County Court Judge to Supreme Court Justice and President of VCAT, and that's barely the half of it. With a resume like that, it's hard to believe that he had no plan to study law until a fortuitous conversation with the guy in front of him in a queue at uni.
Law wasn't your first choice. When you finished high school and were lining up to go to university, law wasn't your first choice. In fact, it was medicine. What happened there?
Yes, I wanted to do medicine. By that stage, you got into a queue and you filled in a form setting out your uni preferences, and I think my marks were enough to get into medicine the year before, so I thought, hoping for the best, I'd get in on my first preference, but that wasn't to be. I hadn't really given any thought to my second preference, but I started chatting to someone in the queue to fill in the form and asked him what he was going to be doing. And he said, arts law. And I asked him what that was about and why did he want to do that. And he said he wanted to be a diplomat, live overseas and travel. And I thought that sounded pretty good, so I put that down. Coincidentally, the person I was talking to, Mark Speakman's now the Attorney General in New South Wales, so he obviously persisted with the law.
Interesting that in that queue at a Sydney University, what must be now, 40 plus years ago.
Well, yeah.
We're standing next to each other and discussing their futures. We're a future Attorney General of New South Wales and a future President of the Fair Work Commission.
Yeah, look, it's a bit weird because at the end of first year, I remember bumping into Mark again, asking him what he was thinking about doing the following year, and he said he was interested in industrial relations, and I asked him what that was about, and he explained it, and I said, well, that sounds interesting. So I transferred to economics law and did industrial relations. Other than those two encounters, though, Mark and I haven't really spoken for the entire time. So
you possibly need to send him a text, I think, Iain, and thank him for your career.
Yeah, indeed.
Our guest this morning on Lives in the Law is Iain Ross, the President of the Fair Work Commission of Australia and a Justice of the Federal Court. Iain, good morning.
Good morning, Michael.
Let's go back to the start. What better place to begin? You were a child who had health issues. You were an asthmatic, you had pneumonia, and it affected your attendance at school. Must have had a big impact on your life up until you were, I guess, in your late teens. Do you think that's correct? And do you think it may have, the person you are today and what you've done in your life might have been affected by that?
Yeah, I think at the time I probably didn't think so, but I think as I look back, I spent most of year 9 in and out of hospital. Year 10, I moved high schools I moved from Caringbah, which is where I had been going, to Orange, and all of that was a bit disruptive. I think it probably did impact me, probably made me more self-reliant.
So there maybe was some sort of a silver lining. What in some ways was a difficult childhood.
Oh, look, I think plenty of people go through illnesses. I've sort of just got used to asthma, really. A large proportion of the population have it, and you just adjust. My career as a professional footballer probably went out the window, but I think that went out the window at the first kick, so I don't think asthma was to blame for that.
You were down in the Shire. You would have been playing rugby league there for the Sharkies.
Yeah, look, I was never really a league person. I was mainly soccer and hockey, but yeah, I don't think the life of a professional athlete was ever really going to open up for me.
You didn't take the traditional path into law, which is finish your university, do your articles, go and work as a solicitor, possibly go to the bar or remain with a firm. You somehow, and I think it seems fortuitous, became a part of the industrial relations scene. Can you tell us about that, what the various steps were that took you along?
It was fortuitous. Look, I didn't... no one in my family had gone to uni. I didn't really know any lawyers. I had no connections. So there was no sort of apparent way for me to follow the more traditional path. I wouldn't want you to think my entire life was just a series of accidents and misadventures, but I was walking up Castlereagh Street one day and a friend of mine came out of the Electrical Trades Union office and we were having a yak, and he said that he had just resigned because he wanted to take up, of all things, long-distance running. He said I should go in and apply for the vacancy.
Can I just check on the long-distance running? I mean, did he have a career in long-distance running? Has he supported himself as a long-distance runner?
No, he did do it for a while, but I think he was trained by Cerruti, who was at that stage, you know, a renowned trainer of middle and long-distance runners. It's never been an area I've looked at much because I'm not even a short-distance runner, so I've never thought much about the long-distance form of the event. So I went in, applied for the job, got the job as a research assistant, and I worked there part-time while I was at law school.
And it wasn't just there. Then, I mean, while you're at law school and after law school, the Commonwealth Bank Officers Association, New South Wales Labor Council, and then the ACTU. Maybe can you take us along that path and explain what you did at these various places?
I applied for a range, I think 40 or 50 positions with unions. When I finished law school, I got one of the Commonwealth Bank Officers Union. I started as a research officer and then became an industrial officer. During that time, I co-authored a monograph on inhalation injuries. And that brought me into contact with the then Health and Safety Officer at the Labor Council of New South Wales, which is like the state branch of the ACTU. John Toohey was his name. John was leaving to go and take up a position at Sydney Hospital, and over a very long lunch managed to persuade me to apply for that position. I did, was successful, and went to work there for a while.
Iain, you applied to, you said maybe 40-odd unions or positions within unions. Why unions? Have you got a political alliance or alignment to the ALP and the union movement?
I think during the course of study at Sydney and working for the ETU, I like the idea of representing workers, and it had been what I was used to. I was enjoying the work, so it seemed like a natural transition for me.
I think, roughly 10 years out of university, you commence a position with the ACTU. I don't know if it started as an industrial officer, but I think it finished as an industrial.
I started as industrial officer and then became legal officer and then ultimately elected as assistant secretary.
So how did it come about that you obtained this position with the ACTU?
I had been interested in working there. I think I had some contact with Bill Kelty, who was then the secretary of the ACTU. There was a contentious issue around work health and safety centres at that time, and I was trying to broker a way through that issue, and that brought me in contact with Bill and Greg Combay, as it turned out, because he was involved with, I think, the Lidcombe Workers' Health Centre at that stage. So I was drafting the ACTU's health and safety policy while I was at the Labor Council. And I remember asking Bill, they'd advertised for a legal officer, and I remember telling him that I was interested in that position. He said, it had already been filled. They'd gone through the process, but he'd let me know if another one came up. And then he sort of rang one day and said there'll be a job for an industrial officer advertised on Monday and you should apply because that's your job. So I did, and I came down to Melbourne.
Did that role in particular, but the roles within the union movement in general, did they involve advocacy? Were you going before tribunals and arguing cases?
Yes, I was. And pretty soon after I arrived, really, I think as an industrial officer, I was mainly looking after the vehicle manufacturing industry. So the then four major manufacturers and the components sector. I also looked after the retail industry and a range of others. And not long after I arrived, I was in the then Victorian Commission arguing a case for the Shop Assistants Union around the introduction of Sunday work.
In today's world, young barristers, young advocates come to the bar, they do the readers course, they're taught advocacy. Obviously, they've always had a mentor who they read with and read with now to learn about advocacy. Were you given any advocacy training?
No. Look, I think it's different now in the same way that courts and tribunals have changed over time. I think if you take a court or tribunal example, you go back maybe 20 years, you'd be appointed and you'd be pretty much on your own. Very little induction. Professional development wasn't really seen as something that judges did. Now, happily, there's a baby judges school, there's mentoring and support as you go through. I think when I started as an advocate, it was more in the sink or swim sort of school of advocacy training. You learnt quickly as you went along.
So what did you do when you came up against an experienced advocate, possibly a silk?
Well, panic was usually the first order of business. Well, in the Victorian case, I was against Chris Jessup.
Who was then a silk?
Yes, yeah. I sort of tended to approach it by probably overcompensating, and I would research the hell out of the case and put a lot of time and effort into preparation, not only of my case but of my opponent's case. But it was nerve-wracking, yeah.
Iain, while you're at the ACTU, you're involved in a very significant piece of legislation ultimately, both from a social point of view and economic point of view, and that was compulsory superannuation. How did that come about?
Well, we had a case before the Industrial Relations Commission to increase the amount of superannuation contributions employers had to make. That was to seek to vary awards to lift the compulsory contribution from 3% up to 5%.
Iain, can I clarify? At that time, compulsory superannuation was a part of individual awards, but hadn't been legislated for.
That's right. So it covered those who were covered by federal awards, but it hadn't flowed to the whole community. And I remember Bill and I were driving somewhere, and he asked me, well, what do we do if they knock off the claim? And they didn't grant it. And I said I thought that we could legislate, or the government could legislate, for compulsory superannuation in the same way, using the tax system in the same way as they had for the training guarantee levy, same legal architecture. And then when they did knock off the claim, Bill rang Paul Keating. Paul came down to Melbourne. We met in the Indian restaurant next to the ACTU. It was, I think, Paul, Don Russell, Bill and myself, and I put the proposition that the government could legislate. Bill obviously supported that resolution because we wanted to get compulsory super up. Paul was in favour but said he'd think about it. He'd talk to the Solicitor General and he then rang back the next morning saying he had spoken to him and looked like it was a go from their end.
And he spoke to the Solicitor General to obtain confirmation that under the Constitution, the Commonwealth had the power to do it. Interesting, isn't it? It's big stuff.
Yeah, look, and then it was, a 2-year slog to get the legislation in. So that absorbed most of the next 2 years of my life, going out arguing for it, fighting with various people about it. And eventually it was implemented, and now it's sort of progressively increasing.
And despite this intimate involvement in the trade union movement, you were never a member of the ALP?
No, I was never active in the ALP. I may have been, I can't remember if I was a head office member, what they described it, in Victoria for a short period of time, but I was never sort of involved in Labor Party factions or anything like that. I always thought there's always been a degree of, cooperation but tension between the industrial wing of the Labor movement and the political wing. And I thought it was just easier for me if I was only in one wing, and then I could advocate for the interests of those people.
After 8 or 9 years with the ACTU, you are appointed Vice President of the Industrial Relations Commission. Mm-hmm. How did that come about?
I had intended to leave the ACTU, and I'd made some arrangements to read at the bar in Sydney. I remember Paul Keating was by then the Prime Minister, having a meeting with him in Sydney and letting him know that I was leaving. And he raised whether I was interested in an appointment, and I thanked him but said no, I was sorted out and I was looking to go to the bar. Then I think not long after, I was quite ill and was in hospital for a while. And as I was lying there reflecting on what life at the bar might be and thinking about my family as well, it led me to ring him and to say, well, if the offer was still open, I would be interested. And then ultimately that led to the appointment.
You're a member of the Industrial Relations Commission, I think, for about 10 or 11 years.
Yeah.
We all know we've got an industrial relations system in Australia. Within the legal profession, it's called a club because there are only those who are inside the club seem to know how it works. Can you educate us a bit, please, on where the Industrial Relations Commission sat within our legal system?
Well, it's both a standard setter and a dispute resolution body. So it has changed over time. It's usually had standard setting as one of its core functions. Now the Fair Work Commission sets the wages and conditions for most Australian employees. There are some limited exceptions, state government and the like, but most employees will have their wages, their minimum wages and conditions set by the Commission. A combination of the Commission and the Fair Work Act, the legislative framework. And it also deals with disputes, both individual disputes. If you think you've been unfairly dismissed, then you'd file an application with the Commission. It also deals with industrial disputes. For example, the rail dispute in New South Wales, so large collective industrial disputes, as well as individual cases. So, look, I think it, one way or another, touches the lives of most Australians.
Iain, can I show my ignorance here by asking you, for a Commonwealth body to exercise all these powers, have the states ceded some of their powers to the Commonwealth to enable us to have this central system?
Some states have, but it also uses the corporation's power to extend coverage. So it's a combination. Victoria ceded power, for example. Other states still have a state industrial commission that deals with unincorporated bodies or state public sector. But if you look at the private sector, the vast bulk are covered by the federal system.
In your time sitting on the commission, what were some of the decisions it made which we may be aware of and have impacted upon our lives?
Well, I think each year there's usually, well, historically and certainly now, it's an annual event where minimum wages are adjusted through what's currently called the annual wage review. There have also been, cases, if I think back over the period, parental leave, introduction of adoption leave, personal carers leave, redundancy pay, reasonable hours of work, various leave entitlements. More recently, pandemic leave and unpaid pandemic leave, and in some sectors, paid pandemic leave, family and domestic violence leave. Annual leave was originally determined by tribunals. It's now in legislation. A number of these areas have been determined by predecessor bodies to the Commission or the Commission, and then have found their way into legislation.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Now, Iain, after your period on the Industrial Relations Commission, you took a turn which seems to me to be possibly at right angles, if not 180 degrees, when you went and worked with a large commercial firm of solicitors in the industrial relations area with them. How did it feel working in a large commercial firm and acting for large corporate employers?
Look, I never really adjusted to practice. I never sort of adjusted to the land of the 6-minute increment. I liked working with clients. I liked helping them solve problems and issues, but I never really felt that comfortable in the large corporate law firm environment.
You worked there for 18 months or so and then you moved on.
Seemed longer, Michael, but yeah.
The 6-minute increments, they would be challenging. I can understand that. Where did you move on to and how did you move on?
Well, I'd been doing some pro bono work with the Victorian Law Reform Commission, and then for a period of time when Marcia Neve left to go to the Court of Appeal, I acted as chair for a while, and that brought me into contact with the then attorney Rob Hulls, and Rob raised whether I was interested in the county court and an appointment as Vice President of VCAT.
And you said yes, you were.
Mm-hmm.
Very different jurisdiction, the county court, applying Victorian civil law and criminal law as opposed to industrial relations. How did you cope? How did you make the transition and how did you cope?
I think, on the face of it, there are sort of sharp differences, but certainly in the civil side of the county's work, there are some similarities as well. I mean, fundamentally, the industrial area I'd been involved in is still broadly part of administrative law. Statutory construction's still a central part of it. Fact-finding, evidence, and developing a case and bringing it within the statutory framework is still the broad task. And I think then at least, I'm not sure now, but about 70% of the county court's work is in the serious injury list. And
that's of the civil work.
Yes, of the civil list.
I mean, I think the majority of their work is criminal, isn't it?
Oh, yeah, and the majority of that's in sex offences.
Yeah.
I sat in the civil list, which is probably just as well at that stage. It was challenging. I worked and prepared as I had in every other place I'd been to and got on with it.
Was there a camaraderie with fellow judges who helped you when you had your trainer wheels on?
There absolutely was, and it was from the top right through the organisation. Michael Rosines was very supportive and helpful. I remember him asking me whether there was any part of the work that I was uneasy about, and I wasn't sure where to start. But I said, getting my head around all the rules. He said, there are lots of practice rules and things, but most of it comes down to common sense and fairness. And if I ever got into strife or I thought I wasn't sure of something, I should adjourn and just give him a call. And look, the judges there were terrific. I particularly remember Michael McInerney, who was next door to me in chambers, Chris O'Neill, Lisa Hannon. They were all very supportive. I remember my first serious injury matter. I'd seen the listing registrar on the Friday. I was due to pick it up on the Monday. And I said, look, I've had a look at all the material and if possible, it'd be nice to start with a straightforward serious injury matter, something that didn't involve the black hole type problem or a raft of other problems these cases could throw up, something I could just sort of settle into. I remember him saying, oh, no, of course, Your Honour, no problem at all. And then the case that confronted me on Monday had every conceivable jurisdictional problem. I could almost hear the laughter coming from the listing registrar's rooms down the corridor. But look, happily for me, on that case, counsel got up at the beginning and said, oh, Your Honour, I wonder if we might have a moment to discuss the matter. I was quick to say, take as much time as you need. And off they went and came back. That matter settled. I contacted listings, got another matter in, and so it went on from there.
You were also Vice President of VCAT, and I assume most of your time was spent at VCAT?
Not initially, but later it was. But I always made a point of going back to the county. In fact, Michael rang me to go back to hear a case involving the Victorian Charter of Human Rights and sex offender registration and monitoring. And I did that sometime after I'd had moved more or less to VCAT. But in the early, certainly the first 6 months or so, I was at the county doing serious injury and other work.
You subsequently become president of VCAT, and also which necessitated you being a Justice of the Supreme Court. Did you hear many Supreme Court cases, or were you principally at VCAT administering VCAT?
I was principally at VCAT, but I did hear a number of Supreme Court cases. So if I had a spare week or so, I would ring up the registrars and ask if they had anything that I could pick up. And I also did a couple of terms in the Court of Appeal.
Iain, I've read somewhere that you were interested in leading VCAT because that's where the rubber hits the road. Why would the rubber hit the road more at VCAT than any other tribunal?
Look, I think in terms of the exposure of people to the legal system, it's most likely through VCAT. It's just because of its breadth of jurisdiction. It deals with civil claims, predominantly small civil claims, domestic building disputes, residential tenancy, so if you've got a problem with your landlord, that's where you'd end up, guardianship, planning, if you've got a dangerous dog, or if you're involved in racing. It's just got a tremendous sweep of jurisdiction. So I was interested in that.
And did you have a vision for what you thought VCAT should be or how it should interact with the public, with our community?
Look, I think that sort of developed a bit over time. When I became president, I spent some time doing some town hall type meetings in the metropolitan area and in regional Victoria, where the public were invited to come along and share their experience with VCAT. And I would also outline the sort of things I was planning on doing to make it more accessible to people so that they would feel that they could come along and run their case themselves.
Iain, are there particular things that you remember from these town hall meetings, events that flowed from them?
Yeah, look, I remember the stories that people would tell me about their encounter with VCAT and what it meant to them. And they ranged, the jurisdiction wasn't important, but it brought home to me that there was a very human element to their interaction with the legal system. So almost in each place that I had the town hall meetings, I would listen and invite comments from the audience, and afterwards there'd usually be a group of people that would want to ask a particular question or take me through their experience, and I would stay until the last one had their say. And some of them, look, they were very moving. Some of them, you can't always redress a legal outcome that they've had. I had one guy sort of follow me from town hall meeting to town hall meeting about a domestic building case he had lost about 4 years before. There wasn't much I could do about that. And I remember a family, a couple I'd met in one of the suburban town hall meetings, that they had a concern about a planning decision. They wanted to understand it, and it had led to a building being built next to them that overlooked their backyard. They had a son with a disability, and they were concerned about his privacy. I remember talking to them. I remember going back to their place for a coffee at the end of the night so they could show me their backyard, the circumstances. So I think it just brings home to you that, you know, the legal system's not about abstract legal disputes. At the end of the day, this is particularly the case at VCAT, there are people involved in each side, and people are affected by the decisions you make.
And Darren Hinch picked up on your town hall meetings, and he wanted to have his say about you and what you were doing?
Yeah, look, Darren was interesting. I mean, he was, I think, at that stage on 3AW, and I remember he was quite critical of some decisions coming out of VCAT around working with children, which has been an area that's been of interest to him for a long time. He had asked that I go on and explain some of the decisions, and so I did. I tried to explain the context. From that, he was interested. Coincidentally, it was the same time we were doing the town hall meetings. And he was encouraging his audience to get along to the Melbourne Town Hall one, which was at the Melbourne Town Hall. And we did get quite a big crowd. And as had been my practice at the others, I went through what I was trying to do, the changes that I was interested in making, that I wanted to hear from them. And then I stayed until the last person had asked their last question. And I think Darren might have been expecting, indeed, as I was in the early stages, expecting a sort of more hostile audience. But I didn't really find people were hostile. I found they were frustrated, certainly. They wanted the opportunity to tell someone about their experience, and they wanted to know that their experience was going to make a difference and it was going to shift the dial a bit. And I was interested in shifting the dial. So the following day, a number of Darren had invited people to give him a call, anyone who had been there, and the feedback was largely positive. And I think that engagement, both with the general public and with Darren, led to a greater understanding about what we did, the nature of our work, and the legal framework in which we were making decisions. And I think that understanding did sort of moderate some of the comments made after that.
It's challenging to keep up with the movements in your career, Iain, because 2012 or 13?
12, yeah.
12, you become president of the Fair Work Commission and also a Justice of the Federal Court. Mm-hmm. Could you tell me how that occurred?
Oh, well, the government of the day put an ad in the paper calling for expressions of interest in the position of president, and there was a similar process for the federal court. So I put in the expressions of interest. The predecessor at the commission had also been, I think, the past two presidents had been federal court judges as well as presidents of the commission. So I put in the expression of interest and away it went.
And so you were back in the industrial relations world, which is where you had come from. I read also that as president, you said you're more interested in preventative action than resolving disputes. Can the commission play a preventative role?
Oh,
and
yes.
if so, how?
Oh, no, it certainly can. One of its functions is to promote cooperative workplaces. I think we've now got a program of promotion in that space that is centred around interest-based bargaining and assisting the parties to develop skills in that space. So they looked for areas of shared interest rather than the things that divide them. And then they work through a process to end up with a resolution. And it's intended to sort of give them the skills and confidence to resolve their disputes directly without having to come into us.
But they see what they've got in common and they work on that and possibly come to you. You can't initiate anything from the commission, I assume. You can't look at a situation and think, that looks a troublesome situation, possibly we need to intervene there. I assume that you haven't got the power to do that.
It might depend on the circumstances whether we'd have the power to do it, but the Cooperative Workplaces program is based on the parties coming to us. So they initiate the contact and seek the assistance and we provide it.
Are you seeing that sort of environment growing now where there is more cooperation and they are coming to you as a neutral third party to help them solve their disputes?
Yeah, I think it's certainly grown over time. I think one of the challenges has been sometimes the parties change. So you might have a CEO of a company who's committed to the idea and an official in a union, and then one or both leaves. And as normally happens when a new person comes in, they want to do something different. And so we've had to adapt to that. So we have seen it go in a cycle. Parties get involved, become committed, it works for a time, and then the personnel changes and it doesn't suit them any longer. But for every one of those, you'd have a couple of new groups come in. So it's grown over time, and I think there's certainly more discussion around cooperation, collaboration.
Iain, the Fair Work Commission has the largest pro bono legal network in the country. I was surprised when I read that. What is the network? Who makes up the network? What does it do?
Well, it started with a fairly small group out of Melbourne where we would partner with some community legal centres, legal aid and a range of law firms. And their commitment was to provide 1 hour of pro bono assistance to a self-represented party, usually an applicant, but sometimes a small business as well. And they would assist them through the legal process of whatever their case involved. Usually an unfair dismissal, could have been a discrimination or general protections case. And then it grew. The demand for it grew and the number of partners grew. And we also grew outside of the CBD, then outside of Victoria, and now it's pretty much national. We have 90 partners across the country, and last year they provided 4,600 sessions to self-represented parties. It's a program that assists everybody. It assists the individual who's getting the advice because they're better able to navigate the system, better able to articulate their case, and they may not be in the right jurisdiction. It assists the party on the other side because if they're not in the right jurisdiction, then both of them won't waste time going through that process. They'll go to a place where they need to be to argue their case. It assists the tribunal and the allocation of public resources because you get a clearer, more focused argument directed at the legal framework for the matter you've got to decide. So, look, I think it's been terrific. It's well regarded by those who receive the advice, and our partners have been terrific through the whole process.
Iain, with your experience in other jurisdictions, could you see it being of value in other jurisdictions?
Oh, absolutely. In fact, look, I started thinking about the idea because there was something similar operating in the federal court, I think in Queensland, where if a self-represented party, and of course, I mean, we've got many more self-represented parties than the federal court because of the nature of our jurisdiction. But if a self-represented party lodged an application in the federal court, they would be referred to Pilch, who would, there was a partnership at that stage between the court and Pilch. They would provide them with some pro bono assistance. And that led to about 30% of cases being withdrawn because they were in the wrong spot or they had no legal argument to support their case. And that was a benefit to the individual because they weren't caught up in the maul of the legal system where there was no outcome for them. It was also beneficial for the party on the other side. They weren't dragged into proceedings that had no prospect of success. And it was a benefit to the public because the resources of the court weren't spent on something that wasn't going to go anywhere. And so that was what started the thinking around it. And we looked at doing something. We didn't have any money, so we couldn't enter into a commercial arrangement with Pilch, so we had to rely on the kindness of strangers. And so we started contacting. Ashurst was a very strong supporter, particularly in the early days, and then it sort of spread, and we started writing to firms that had had some contact with us or had been in cases. And over time, it's grown. And now it's quite a sophisticated system of, so they're able to check for conflicts and the like. It's essentially an online booking arrangement, and it works pretty well. And yeah, I think there's certainly potential for it to work elsewhere.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
To move on to a couple of current issues before you and before the Parliament. One is there's a bill before Federal Parliament now for paid family and domestic violence leave. What role did the Fair Work Commission play in the development of this piece of law or future piece of law?
Yeah, well, not so much in the content of the bill, but in the idea. A number of years ago, the Commission heard a case around a claim for paid family domestic violence leave, and in the end result awarded unpaid family and domestic violence leave, and said that it would revisit the question of paid leave after the unpaid provision had been in operation for a while. The government of the day, at the time we introduced unpaid leave, then moved to legislate for unpaid leave as a general entitlement. Then we handed down a decision earlier this year which said that the merits favoured the provision of paid leave. And we expressed some views about the quantum of that leave, 10 days per annum, and a range of other issues. Then the now government introduced the bill, and in doing so referred to the Commission decision. It had been, I think, the government's policy prior to our decision to introduce paid family and domestic violence leave, but that's broadly the way or the sequence of events. Not unusual historically for the Commission to determine a case and then for that case or the results of that case to ultimately find its way into a legislative entitlement.
Iain, the other current issue is the minimum wage increase, which, depending on what I read, it's either 4.6% or 5.2%. So you might clarify that for me, please. And also clarify for me, how do you reach a figure? What do you take into account as a tribunal? Do you take into account the cost of living? Do you take into account the ability of employers to pay, inflation? Probably all those things, I guess. But could you please tell us what you take into account?
Sure. Well, you're right about the amounts. It's both 5.2% and 4.6%. It is slightly confusing, but it's intended to provide the higher increase, 5.2%, to those who are on the lowest minimum wages. And then when it reaches a certain point, the 4.6 cuts in. That's for those on higher minimum award wages. Yeah, there are a range of things under the statute that we're required to take into account, both the needs of the low paid and relative living standards. We're required to take into account the impact on employers and on the national economy, things like inflation, unemployment and the like. So all of those things were exercising our mind when we made the decision.
Do you find it gives you great satisfaction to be involved in decisions such as these, such as domestic and family violence leave or paid leave and a minimum wage increase at a time when wages have been static for a long time in real terms? Is there satisfaction in being involved in these important social decisions?
I'm not sure that satisfaction's the right... Look, I think when eventually it comes my time to head off into the sunset, I might look back on it and think that. I think at the moment, in the middle of it, I tend to feel more the weight of it than I do anything else.
The weight, the importance of these decisions and getting them right.
The responsibility, I think.
Yeah.
So I feel that more at the time than any other emotion.
That brings me to a question about leadership. I read also where you believe one of the elements anyway of leadership is to work the hardest.
Yep, I think that's right.
Could you reflect on other elements of leadership? You hold and you have held regularly positions of leadership.
I think leading by example, so that is about hard work. There's also, I think, articulating a clear direction and vision for the organisation you're in. Those are probably the central sort of products, if you like. I think in developing whatever the direction is you want to take the organisation, it's important to listen to a broad range of people and take into account their views. And then I think it comes down to will and the implementation of it. So it's then executing, and that sort of requires unwavering commitment, really.
And also bringing people along with you?
Yes, and that's about communication, letting them know what you're doing, and celebrating the successes that the organisation has along the way and acknowledging those who've contributed to that success.
From the time that you started as a research officer with the Electrical Trades Union through until the present, as president of the Fair Work Commission, have you had an overall philosophy, guiding philosophy, that guides your life?
Yeah, not that I've thought of. I think it's important that you try and make a difference. You try and make the society you live in better than when you arrived in it. And everybody does that in different ways. And I think that's important.
Can I just go back to another issue, well, not a broad issue such as guiding philosophies. You're a justice of the federal court. Do you sit and hear matters in the federal court? Have you got the time to do it?
Not recently, certainly not since the pandemic hit. But prior to them, I would hear the occasional matter in the federal court. I would do, not many, but I recall doing a week or so of immigration appeals. I've done a general protections matter, and I've sat on appeals in the federal court, but it's not been a regular feature of my work. If anything, I probably sat more frequently in the ACT Supreme Court, certainly in the first within the first 5 years of being on the commission.
Did you find that you didn't have enough time, work in to fill the time of your life, Iain? Therefore, you decided you'd be on the ACT Supreme Court as well.
There are a number of federal court judges who are on the ACT Supreme Court. I was interested in doing it because they do crime. And I think it sharpens up your thinking in your main area of work if you can work in another area as well. Crime had done that for me. And it's I remember talking to Pat Keane, who was then the Chief Justice of the Federal Court, that I found sitting on the ACT Supreme Court a bit of a mental health break, because you're away from your day-to-day phone calls and the concerns in your organisation. I think Pat had the same sort of feeling. When he was sitting on the bench, there was the administrative burden and everything else fell away, and you focused on the case in front of you. Yeah, I thought it was a great experience. I enjoyed working there.
To go back to start of your university career, any regret that you didn't become a doctor?
Not really. I don't, as a person, I don't really look back and wonder about, the road not taken. I think I've been lucky enough to do stuff in the law, whereas if I'd been a doctor, I wouldn't have had the breadth of experience. So my sort of career trajectory might be unusual for someone my age, but I think increasingly younger people are looking at 4 or 5 career changes and options during their life, and I'd certainly encourage that. It means you don't get bored.
And you've had a varied career. I mean, I think probably the most varied of any person that we have talked to in Lives in the Law. To do a little bit of looking back, reviewing your career, what would you say to young lawyers coming into the profession today? Are there any lessons you've learnt that you think would be helpful to them or helpful to a young Iain Ross?
I can think of a number of lessons that would be helpful to a young Iain Ross that I wish I'd thought about at the time. I think if you're coming into it, if you're studying law, I think the main thing is to be the great thing about a legal background is it can open up so many different pathways. So just be open to all of the different pathways that might be in front of you. And it's not like you're necessarily stuck on a particular trajectory. That is, you do articles, you work as a solicitor, go to the bar, etc. There are many different pathways. Don't feel frustrated if the one you had thought of isn't the one that opens up for you. Take the one that comes in front of you, make the most of that, and think about what you might do next.
Iain, thank you for joining us today and telling us about your very interesting and varied career. We appreciate your generosity in coming to us today.
No problem at all, Michael.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.